life, this controversy with Jefferson seems to me the most equivocal, and it was a direct effect of a constitutional system which has permitted the courts to become the censor of the political departments of the government. Marshall probably felt exasperated by Jefferson's virulence against these final appointments made by John Adams, while Marshall was Secretary of State, and for which he may have felt himself in part responsible. Possibly, even, he may have taken some of Jefferson's strictures as aimed at himself. At all events, he went to extreme lengths in retaliation. He might have dismissed the litigation in a few words by stating that, whatever the abstract rights of the parties might have been, the Supreme Court had no power to constrain the President in his official functions, but he yielded to political animosity. Then, having taken a position practically untenable, he had to find an avenue of retreat, and he found it by asserting a supervisory jurisdiction over Congress, a step which, even at that early period, was most hazardous. Footnote: Marshall's constitutional doctrine was not universally accepted, even in the courts of the Northern states, until long afterward. As eminent a jurist as Chief Justice Gibson of Pennsylvania, as late as 1825, gave a very able dissenting opinion in opposition in Eakin v. Robb, 12 S. and R. 344. End of footnote. In reality, Jefferson's temper, far from being vindictive and revolutionary as his enemies believed, was rather gentle and timid, but he would have been more than mortal had he endured such an insult in silence. Nor could he, perhaps, have done so without risking the respect of his followers. So he decided on reprisals, and a scheme was matured among influential Virginians, like John Randolph and Senator William Giles, to purge the Supreme Court of Federalists. Among the associate justices of this court was Samuel Chase, a signer of the Declaration of Independence, and an able lawyer, but an arrogant and indiscreet partisan. Chase had made himself obnoxious on various public occasions, and so was considered to be the best subject to impeach. But if they succeeded with him, the Jeffersonians proclaimed their intention of removing all his brethren seriatim, including the chief offender of all, John Marshall. One day in December 1804, Senator Giles of Virginia, in a conversation with John Quincy Adams, has reported in his diary, discussed the issue at large, and that conversation is most apposite now, since it shows how early the inevitable tendency was developed to make judges who participate in political and social controversies responsible to the popular will. The conversation is too long to extract in full, but a few sentences will convey its purport. Quote, "He treated with the utmost contempt the idea of an independent judiciary, and if the judges of the Supreme Court should dare, as they had done, to declare an act of Congress unconstitutional, or to send a mandamus to the Secretary of State, as they had done, it was the undoubted right of the House of Representatives to impeach them, and of the Senate to remove them for giving such opinions, however honest or sincere they may have been in entertaining them." And a removal by impeachment was nothing more than a declaration by Congress to this effect: "You hold dangerous opinions, and if you are suffered to carry them into effect, you will work the destruction of the nation. We want your offices for the purpose of giving them to men who will fill them better." End quote. Jefferson, though he controlled a majority in the Senate, failed by a narrow margin to obtain the two-thirds vote necessary to convict Chase. Nevertheless, he accomplished his object. Chase never recovered his old assurance, and Marshall never again committed a solecism in judicial matters. On his side, after the impeachment, Jefferson showed moderation. He might, if he had been malevolent, without doubt, have obtained an act of Congress increasing the membership of the Supreme Court enough to have put Marshall in a minority. Then, by appointing men like Giles, he could have compelled Marshall to resign. He did nothing of the kind. He spared the Supreme Court, which he might have overthrown, and contented himself with waiting until time should give him the opportunity to correct the political tendencies of a body of men whom he sincerely regarded as a menace to what he considered popular institutions. Thus the ebullition caused by Marshall's acrimony toward Jefferson, because of Jefferson's strictures on the appointments made by his predecessor, subsided, leaving no very serious immediate mischief behind, save the precedent of the nullification of an act of Congress by the Supreme Court. That precedent, however, was followed by Marshall's Democratic successor, and nothing can better illustrate the inherent vice of the American constitutional system than that it should have been possible in 1853 to devise and afterward present to a tribunal whose primary purpose was to administer the municipal law a set of facts for adjudication, on purpose to force it to pass upon the validity of such a statute as the Missouri Compromise, which had been enacted by Congress in 1820 as a sort of treaty of peace between the North and South, and whose object was the limitation of the spread of slavery. Whichever way the court decided, it must have fallen into opprobrium with one half the country. In fact, having been organized by the slaveholders to sustain slavery, it decided against the North, and therefore lost repute with the party destined to be victorious. I need not pause to criticize the animus of the court, nor yet the quality of the law which the Chief Justice there laid down. It suffices that in the decade which preceded hostilities no event, in all probability, so exasperated passions and so shook the faith of the people of the Northern States in the judiciary as this decision. Faith, whether in the priest or the magistrate, is of slow growth, and, if once impaired, is seldom fully restored. I doubt whether the Supreme Court has ever recovered from the shock it then received, and considered from this point of view the careless attitude of the American people toward General Grant's administration when, in 1871, it obtained the reversal of Hepburn v. Griswold by appointments to the bench, assumes a somber aspect. Of late some sensitiveness has been shown in regard to this transaction, and a disposition has appeared to defend General Grant and his Attorney General against the charge of manipulating the membership of the bench to suit their own views. At the outset, therefore, I wish to disclaim any intention of entering into this discussion. To me it is immaterial whether General Grant and Mr. Hoar did or did not nominate judges with a view to obtaining a particular judgment. I am concerned not with what men thought, but with what they did, and with the effect of their act at the moment upon their fellow citizens. Hepburn v. Griswold was decided in conference on November 27th, 1869, when 8 justices were on the bench. On February 1 following, Justice Grier resigned, and on February 7 judgment was entered, the court then being divided 4-3, but Grier having been with the majority, the vote in reality stood 5-3. 2 vacancies therefore existed on February 7, one caused by the resignation of Grier, the other by an act of Congress which had enlarged the court by 1 member, and which had taken effect in the previous December. Chief Justice Chase held that the clause of the currency laws of 1862 and 1863, which made depreciated paper a legal tender for pre-existing debts, was unconstitutional. No sooner had the judgment been recorded than all the world perceived that, if both vacancies should be filled with men who would uphold the acts, Hepburn v. Griswold might be reversed by a majority of 1. The Republican party had full control of the government and was united in vehement support of the laws. On March 21 the second of the 2 new judges received his commission, and precisely 10 days afterward the Attorney General moved for a rehearing, taunting the Chief Justice with having changed his opinion on this point, and intimating that the issue was in reality political and not judicial at all. In the December term following Knox v. Lee was argued by the Attorney General, and on May 1, 1871, judgment was entered reversing Hepburn v. Griswold, both the new judges voting with the former minority, thus creating the necessity majority of one. No one has ever doubted